My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. I'm often hired by beneficiaries in an estate to simply monitor the progress of an estate and to ensure that their interests are protected and that they're receiving what they're supposed to receive under the will or under Texas law if it's an intestate administration. What are the tools that a beneficiary has to obtain information or to ensure compliance with the terms of the will or the law? Well, a couple of things. First of all, a fiduciary, as an executor administrator, always has a general duty of disclosure to beneficiaries. And a lawyer that represents a beneficiary can ask for information. But what about a formal tool that Texas law provides? Well, Texas law provides two things. First of all, an administrator, an executor, is supposed to file an accounting within 90 days of the will being admitted to probate and the executor being appointed. They can ask for an extension, which will often be granted. But if the executor administrator does not provide the inventory, they can be removed. Second, 15 months after the executor is appointed, a beneficiary can ask for a formal accounting under the Texas Estates Code. And that is a detailed accounting of the assets that have come into the estate, the expenses that the executor has paid, any distributions that have been made, and what's left in the estate. It gives the beneficiaries a full picture, a full accounting of what's happened in the estate. Now, I've been hired many times to write a letter to the executor as a lawyer asking for an accounting, and usually they comply. But occasionally those requests have been ignored. Well, what do? Well, I simply file a motion to compel an accounting in the probate court, and generally that motion will be granted and the executor will have to provide the accounting. But what if they don't? And occasionally this happens. And then the court has various tools at their disposal. First, the executor can be removed. But the court also has its inherent contempt powers. A probate court can order an executor to provide an accounting with supporting documentation, or the executor can be held in contempt. And that would generally be contempt that says you can be fined or you can even be confined in the county jail until the executor purges themselves of the contempt. And in this situation, all they would have to do would be to prepare the accounting and provide these supporting documents, and they would be purged of the contempt. Those are some powerful tools that a beneficiary can use to ask the court to compel an executor or administrator to provide the accounting that often may be important, particularly in large or complex estates, or where there is simply a level of mistrust between the beneficiaries and the executor. If you're dealing with a contested estate in which the executor won't provide information, feel free to give me a call.